just the sheer volume of capital that is flowing into the market. A lot of these smaller, more regional firms are going to have a very hard time competing.
Yeah, I think it's called consolidation for a reason. You're going to have, these firms come in and make those plays, continue to acquire, make add-ons so that the market has less players.
Welcome back to the John and Mark podcast. We're here at Mass Torts, Puerto Rico, We're here at Mass Torts, Puerto Rico. There was just a session on law firm acquisitions, mergers, private equity, and we have 5 of the panelists here joining us. We're going to go around just brief introductions of who each of you are and the organizations that you represent, and then we're going to get into the things that weren't asked of you on that panel that I think everybody really wants to know more about. So Boris, if we want to start with you.
I'm Boris Ziser. I'm a partner at McDermott, Will & Schulte, and I run the specialty finance practice, and MSOs and litigation finance and law firm lending is part of that practice.
I'm Benji Grossman. I lead a company called Commonwealth Island Capital. We are a MSO focused on the personal injury space, doing MSO transactions with personal injury firms around the country.
I'm Josh Porte. I'm a partner with Holland & Knights. I co-lead our legal services transactions team, where we focus our efforts on representing buyers and sellers in connection with MSO deals.
Tom Lenfestey. I run the Law Practice Exchange, a national marketplace for buying and selling law firms. So over the last 13 years, we've been helping just do that, bring those value transactions together. And we've been excited to see the marketplace grow, especially over the last 2 years.
Hi, I'm Juan Acevedo. I work for the Milberg Law Firm. I'm a partner here in Puerto Rico, and I deal mostly with first-party litigation, and I've been in charge of researching and looking at the opportunities created by the new Rule 5.4 here in Puerto Rico.
Awesome.
Thank you, everybody, for being here. I know you're super busy. You came straight from the panel. I've been looking forward to this all day. We have a bunch of questions to ask. We have some extremely smart people on this side. I'm a little scared. But John, I wasn't able to sit in the panel, but I did get all the notes.
Yep.
You sat in. You have a laundry list of questions we want to get into. I have a laundry list. What's the first one on your priority list here?
Seth isn't here. We tried to find him after the panel, but he said something that was at the top of my list that I want to get all of your, or some of your perspectives on. He said law firms, I'm paraphrasing here, but law firms are one of the more tech-forward and business-minded operations and industries. Again, paraphrasing a little bit, but to me, I immediately step back. I'm like, wait a minute, that doesn't make any sense. Like, Mark and I only work in the legal space. We've had a little bit of exposure to the other industries, and I could tell you, even from that little bit of exposure, I have not seen a law firm run a law firm like a true business, other than the top 0.5%.
Yeah, I can take that. I think Seth was referring to plaintiffs' personal injury lawyers and mass torts law firms as being the most business-minded of the legal community in general.
Oh, legal community. Okay, that makes more sense.
Yeah. So these are people who track their, KPIs, their metrics, their numbers religiously. They know what their case acquisition costs are. They track time on desk. And very different from, say, a Holland & Knight or a McDermott, Will & Schulte, where we are more or less dinosaurs, I think.
I think that's right. I'm not going to share the dinosaur description with Josh, but the reality is that firms that are constantly doing intake and case analysis all the time, they've been using technology longer than a lot of other firms to aid in that process. Now, of course, the bigger firms are catching up and taking AI very seriously, but I think that's what we were talking about.
So it's your understanding that plaintiffs' firms are the least dinosaur of the dinosaurs.
Correct. Yeah.
That's an interesting way to phrase it.
Give me another metaphor. I don't know.
Metaphors aren't your strong suit.
If plaintiff firms are truly on the cutting edge of legal, I still think there's a ways to go. So you're making comments about tracking intake and KPIs and time on desk. I could tell you with confidence, having seen this from the law firm side, that those data points are rarely as accurate as the firms actually think they are.
And that's probably true. And not all plaintiffs' firms are created equal in that regard. I think some are more tech forward, as you say, than others. But I think to be efficient when you're doing a large volume of certain types of things, I think maybe they were forced to adopt technology sooner. But I'm sure that it varies.
Yeah, I think least dinosaur of the dinosaurs is a good description because, and I think part of the reason for that is that there hasn't been this outside capital into the space, that any sort of investments in technology needed to happen from the pockets of the owners of the firms. And that's just not something, this is a very different calculation than when outside capital is coming in and doing it at scale. So that's why it's still, even that least dinosaur is still a dinosaur relative to other industries. And it's really just the larger firms that have adopted the technology. And there's a huge gap between what they've done versus the kind of smaller players.
I have a question in the back row from like the exchange side when people are listing their firm for sale. Is a lot of that information listed in the listing of like which technology they're using from platform side, or evaluated at all besides like basic high level numbers about, like caseloads, earnings, stuff like that?
Sure, there may be highlights, but typically, most of that is behind the door, from a confidential aspect otherwise. And so usually what you'll see is some of that technology, they may list some of the software they're using and other highlights, but usually that's next. Once, NDA is signed and there's some more conversations and disclosures is really where things come out and kind of carry forward. And just to, kind of share that's really in the discussions, the meat of, those firms that do have strong technology, do have strong systems, they are going to be more valuable. But going back to, this whole comment on, really are personal injury the most advanced? The answer is yes, across the board. And it's probably because they were the first ones to spend more on marketing. And then once they spent on marketing and intake, they really figured out they needed to spend, to make sure their operations, their technology were better. Is there room for improvement? Absolutely, in personal injury. Is there room for improvement in other practice areas, which we see a lot of on the exchange and otherwise? Even more so, right? So I think, to that point is, the overall aspect is they're more advanced, but overall that's not saying a lot.
There were questions towards the end about plaintiff firms, not just in the personal injury space. And we started talking about this a little bit regarding mass torts and the acquisition of firms that are more focused on mass tort litigation versus personal injury, or sort of those hybrid firms that kind of dip their toe into mass torts. We're at Mass Torts Puerto Rico. I want to talk about mass torts and any experience that any of you have regarding even attempted acquisitions of mass tort firms, because there are a variety of different types of mass tort firms. You've got the firms that are actually handling the cases, that are receiving referrals from other firms. You've got the PI firms that are making incremental investments into mass tort dockets. And then you have the marketing mass tort firms. They're the aggregators who they do nothing other than acquire the cases and then refer them to someone else who does the handling. Of the mass tort discussions that you all have been a part of, which bucket do you see those discussions falling into with which types of firms?
Yeah, we really have bucket B, right? Those PI firms that have a significant, systematic approach to mass torts. We have a deal working through that's set to close in the next couple of weeks of that. We have not had the experience to work a deal through on option A or option B or option C yet, or bucket A, bucket C. But I think the time will come, and really it's a question of those deals are getting done. They just may not be getting done with, private capital, private equity, which was the kind of goal of discussion of this panel. They're getting done with traditional buyers, which may be law firms, others that understand and know how to fund those mass torts, run those mass torts claims in the systems beyond.
The challenge, I think, for private equity with mass tort firms is the unpredictability of cash flow. It's the duration, and private equity also has a limit on fund duration. So you need an exit, and oftentimes, maybe not everybody, but oftentimes you need an exit. And so to have this type of unpredictability doesn't always lend itself to private equity investment, unlike a personal injury firm that has a much more consistent and predictable cash flow model, which makes it much more accessible.
Mass torts usually, not always, have a lot larger debt sheet, potentially, if they're acquiring the cases themselves.
Well, they'll just have, depending on, again, which bucket they fall into, if you have a lot of cases, that's a lot of risk. That's a lot of assets that are just sitting there that could potentially mature at some undefined timeline, at some undefined value. And I can imagine that being really difficult to peg a number to the value of either an existing docket or the marketing engine that generated those cases. Is that part of the firm? Is that not part of the firm? Is that proprietary in any way? It seems like a lot of question marks. And potential for, risk aversion from the investor side.
I know we were talking about plaintiffs firms, but is personal injury the most popular in this model that the private capital and private equity are going after?
Yeah.
So far.
Yeah.
So far. There are also plaintiffs firms that aren't personal injury firms, but are plaintiffs firms in other areas, for example, employment. Right? It's not personal injury, but it's different genre, but still contingency. And there's also an increasing amount of interest by private equity in hourly firms, large firms, middle-sized firms as well, that are not just a contingency fee model.
The investment activity right now, the consumer and kind of retail-oriented end of the market is in general is very, very active. So firms that are engaged in mass advertising to the general public for their client base, because that model, whether it's plaintiff's personal injury or immigration or family law or trust and estates, it is, the investment thesis is very clear, right? It's you can increase size, sophistication of marketing spend. You can use technology because a lot of this work is like volume, rinse and repeats type work, which is very susceptible to, disruption via AI. And a lot of these firms are very closely held, right? So in terms of founder dynamics, structuring a transaction involving an AM law firm with 600 equity partners, much more complicated than a closely held, immigration firm that has 2 or 3, partners.
Yeah, main partners, a lot simpler capital table to negotiate.
That's right.
Yeah, and I think a key part to that too is, as Josh mentioned, the closely held in personal injury, they get to the right earnings or the EBITDA platform that private capital really wants to see, where in other firms that are closely held, other practice areas, trust and estates, family law, there's just less of those in the market. They're smaller firms. They don't make as much money as, we've kind of mentioned. They may not have the systems, the brand, and otherwise. So they're just not ideal targets for this early entry space, as I think even Josh calls it, like inning one, right, of this market build with private capital. And so they're less ideal. They're interested, but there's going to take some market movement to really get those other practice areas.
So a term you guys have thrown around, and I hear it every time you guys are talking about acquiring law firms, is you're analyzing EBITDA. For those who don't know what that is, because it's not a very commonly used term, especially in law firms, explain that to me like I'm in 5th grade, or I'm not as smart as you guys.
So EBITDA stands for earnings before interest, taxes,
Econ 101, here we go.
amortization. The reason that you look at that is that in the context of these transactions, you want to look at a metric that's capital structure independent, and the buyer might not have the same interest and tax profile, and you want to look at what's the true cash profitability of the firm going forward. So for law firms, it's actually very clean. They're very asset light. Personal injury firms often have no debt. It typically is going to be EBITDA is pretty close to what you would have in terms of the taxable income or distributions. It tend to be relatively equal for personal injury firms, but it's called EBITDA because that's what you would use in any other industry. And when it's more capital intensive and the D and A of EBITDA is more important, and you want to take into account capital expenditures, it would be more relevant. But here it's the same as just the profitability of the firm.
When it comes to the buyer being able to extract value out of the asset quickly, right? You're talking about structures and the differences between the various types of buyers, whether it's other law firms or it's private equity or some other type of acquisition. There's talk about MSOs, there's talk about Puerto Rico, there's talk about Arizona, the ways that a buyer could come in and instantly add value to that law firm and increase that valuation very quickly just by the sheer fact of how they are structured and how they handle their operations, and then rolling that individual law firm into that way of them doing business or their structure. Can any of you kind of talk about how you're able to see that like happen very quickly and provide immediate value?
For every one of these deals, there needs to be substantial upfront conversations between the buyer and the sellers in terms of what the go-forward business plan is and what will technology rollout look like, what will kind of staffing and support services look like post-closing. And as we've already said, like these are in general are fairly inefficiently run businesses. And so there does tend to be kind of a lot of room for improvement. We do need to be thoughtful about this from a regulatory standpoint because there are restrictions on lawyers' ability to split fees with non-lawyers. And so If you increase the margin of the firm, great, but you need to make sure that you're able to increase the fee that is payable to the MSO in order to extract that value, which becomes a regulatory question. So all of it, the legal, the regulatory piece needs to go kind of in conversation with the economics.
And also, you have to think about if you were to increase value, there's value for value's sake, and then there's market value. And what's easier? In what kind of structure is it easier to do that? In what you're referring to as Puerto Rico or Arizona, those are ABSs, alternative business structures. Those are actually law firms that have a license to be an alternative business structure, which just means that non-lawyers can own equity in the actual law firm. So if you were to increase value and then say, well, what would the exit look like, for example? Well, you're still selling a law firm or an interest in a law firm, whereas in an MSO, you're actually selling a service provider, a business that provides services to one or more law firms. And law firms have historically outsourced a lot of things, whether that be word processing or whatever, duplication, doesn't matter. And so it's a much more, from an investor standpoint, accessible concept, because you've built a service provider business that provides services to a very long-standing industry, as opposed to a law firm, which might be more difficult to sort of think about and get your arms around. So I think that if you were to say, well, where can we increase value? I think increasing the value in an MSO structure where it's a service provider is, I think, easier in some sense than if it's a law firm.
Where do you all see these deals go sideways post-acquisition?
How do you see them go sideways during the deal and then also post-acquisition?
I think during the deal is probably more common, and right, because then there's sort of a separation and things never get consummated. I'm genuinely interested in like what happens post-acquisition when like the relationship sours. How does that manifest into either a breakup or what happens?
So there's not a long enough track record to be able to say with specificity what that really looks like. There's a couple of bankruptcy cases that are available to us. So there's one called United Lex. The MSO, put a bunch of debt on the law firm. The law firm had to declare bankruptcy, and then the MSO was trying to extract kind of preferential payments. And the bankruptcy court actually kind of pierced this and said that the MSO was, exerting improper influence and control over the law firm because that was an improperly structured arrangement. And so did not allow the MSO to kind of recover in that bankruptcy proceeding in the way it otherwise might have been able to. So you can definitely see the outer contours of where the relationship could break down. We could look at other industries as well for an analog and know, more so how it might play out. Healthcare and accounting, for example. A breakdown between the lawyers who own the law firm and the investors who own the MSO is very dangerous. It really is. You can imagine kind of the court pleadings that could be filed, asserting improper conduct, whether true or false. You can imagine an entire parade of horribles that could result from that. And so there's definitely danger there. To mitigate that, it's incredibly important that on the front end, you have detailed conversations, buyer and seller, talking about, again, what the arrangement is going to look like post-closing, who's responsible for what aspects, and make sure there's good alignment going into that relationship.
And also, just like any other corporate transaction, you could do a majority deal, you could do a minority deal. And so if private equity owns a majority of the MSO, you have minority rights. And or if it's the other way around, you have the majority, they're going to want minority rights. And so I think it's as Josh was saying, planning ahead, and because the issues aren't new. These are the same issues you deal with other M&A type transactions. You just have to think in advance and then contract around who actually drives the bus and in what circumstance.
It's so interesting because when I think about like acquiring law firms, one of the things that I really struggle to wrap my mind around, it's not like, hey, you're buying a Superior Plumbing where it's just a company name. Like there's the owner, but it's known as the company. When you're buying a law firm, it's like you're buying John and Mark Law Firm. So you're buying equity in that firm, but it's that person's name still tied to it, even if they're involved or when they're not involved. And there's still a huge emotional attachment to that of it's a company you built as a business owner. You do have a certain very like your child that you built, but then your name's actually attached to it, whether it's one name or a couple names as the main partners that is now being controlled by something else. It brings another personal relationship.
But
to it.
that might drive whether you do a minority deal or a majority deal. If you have that type of attachment, maybe a majority deal is not a great idea for you.
Yeah, we had a deal last year that name, image, likeness agreements, which, these guys in front of me definitely do. And when our seller got that agreement for the first time, it really took him back because it's his name, his image, his likeness to be used in perpetuity, right? Because that's what they're buying. You built your firm around that. And so overall, now you are selling that, which is always a strong, if you're looking to build a firm, maybe you don't build it around your name personally or otherwise, if that's going to really be a challenge. But I do think to that point, it was a big emotional hurdle we had to come over, because when they read that and they read that, the buyer can create AI versions of them and just other things, which is what they're buying, that's a lot of emotional gut check right there in transferring it. So the biggest thing is to be aware of that. If you're building a firm around you and you've been the face of the firm and the commercials and the billboards and otherwise, that is what you're selling, right? That is what you're transferring. And the other is, if you want to change that, build a firm that's not built around you, right? Or your personal brand, because it is a challenge.
Let's dig into that. So Benji, I want to get your opinion on this. You're evaluating firms. What would you recommend to firms who are trying to, let's say, looking 2 to 3 years ahead, and their exit strategy is to sell to someone like you or Tom, right? Like to list on your exchange. What are the things that you would recommend firms do now to prepare their firm for an acquisition at some point in the future?
Yeah, there's a couple key things there. One of the ones is what he mentioned is the less the firm relies on you, the more flexibility you'll have in terms of transaction structures and what a buyer will ultimately need from you in the context of that transaction. So the more operational support you have and management team built around you, the better it is. And it has a direct impact on the multiple of EBITDA that ends up being paid. In addition to that, there's just the normal things you would prepare for the context of a sell, which would just be having the right data, the right financial profile, having a couple years of track record there, so that there's the buyers and then the capital providers that are underwriting it from both the debt and equity side can feel comfortable with the financial profile of the firm.
Yeah, and I really add, I talk about value of a law firm being built on financial systems and brand. And, for systems, if the systems are relying on you as the owner founder, right, you're going to have lower value. And if the brand's built around you, the owner founder, you're going to have a lower value typically, because there's some kind of transition risk, a transfer risk that a buyer is going to see of, will this brand, if this owner, this founder is no longer around, will it really transfer and carry forward? So I would say the other part is they have to figure out, and this is the new space as this consolidation market picks up, what do they do with these brands once they acquire them? Do they continue to run them separately? Do they roll them into a merge brand over time? And otherwise, this is a buyer strategy. But if you're a seller and can help them figure out that strategy, if you're 5 years, 10 years, 20 years away from potentially selling, it may be looking at things that aren't you personally as your brand to kind of build out a more valuable, more transferable law firm.
I've been thinking a lot about this. I think there's 2 ways to look at this. One is how much growth could come from the firm. And in that regard, it's all about caseload, right? How many cases are coming through the door? What are the marketing sources of those? Are they sustainable? Are they scalable? Are they efficient? So there's the revenue side, and then there's the operational efficiency side. What are the things that we are doing that are better than our peers, that are going to make us stand out and more appealing and add value more so than just the firm itself, but are going to add value to the acquirer? When you're looking at an MSO, right, are you going to bring something to the table that is going to make you appealing because it's going to help enhance the overall brand that is acquiring you, that can be rolled out across the entire operation, whether it's marketing or it's operations? I have these conversations all the time with our clients, and everything from like shifting from like the firm owner's name as the brand to a more white label brand that they are less tied to, or like they're saying, should we move from a legacy case management system to a cloud-based, API friendly case management system, integrations with accounting systems and making sure that the data is flowing the way that it needs to? Do you have succession plans in place, not just for you, but for your key people, right? Every firm has like their either it's their main operator or their head of intake, or there's like one person that's sort of the glue that holds that firm together, right? Like Juan in Puerto Rico, right? If Juan goes away, right, the operation in Puerto Rico is in big fucking trouble, right? You run that whole operation, and there are firms that are going to experience, I think, that same thing when it comes time to having these like real conversations with potential acquirers.
Retention is a related topic. You know, you talk about succession, but hand in hand with that is also retention.
Employee or client?
Employee retention, yeah.
But I think the biggest, as you talk about that, that is the thing that I've seen over a decade of doing this is firm owners didn't want to hear about that. It was really about
Which part?
really any of it, right? Of building it.
Write me a check so I can go away, right?
Well, it was building a better business to draw profit from that business, but they weren't motivated about building a better business for succession, exit, monetizing that value. And that's where it's exciting for me to see the growth, especially over the last couple of years, of the market overall, because now you have founders and owners, when you guys have those conversations, it's not just about because you're going to build a more profitable, better to run business, but also because you're going to have a higher value when you exit it, right? If you do these things. So it's not just investing for the short term, it's investing now for the long term. And I think that's a really cool opportunity for these attorneys that founded to see that they didn't have before. It was theoretical, right? And now it's becoming reality. If you do these things, you will build a better ready to exit practice that probably you're going to make more money over the next 10, 20 years running it, but it's going to, exit for a higher value under an easier transaction with potential, the perfect ideal choice because you've invested in that. And that's exciting just to see lawyers who founded these invest and then have good choices.
Yeah, no, absolutely. In order to be an appealing target for an acquisition, you have to be running a great operation now. You have to have happy clients now. You have to have happy employees now. You have to have sustainable marketing sources now, right? And if you start having those conversations internally, once you get to the point of wanting to sell, you're way behind the 8 ball, and you cannot turn a giant ship instantly, right? It takes time for it to turn and for you to put all those things in place. So for firms interested in looking ahead at the money coming into the space or the money already here, start thinking about those things, start figuring out where you could turn the screws, make a great operation. And if you wind up not getting acquired, great, you've got a better operation, right? You have better employee retention and you potentially have more profitability, but you also become more attractive to an acquisition. In the agency space, right? Mark and I live in the legal marketing agency world, and there has been extensive private equity acquisition of marketing agencies in the legal space. I could rattle off half a dozen of them that have happened in the past 2 years. And when we talk to law firms who were working with some of these agencies that were acquired, there's the narrative that happened before the acquisition or right when the acquisition happened of, don't worry, nothing's going to change, service is actually going to be better. And then there's a narrative post-acquisition, which is the reason why they're having a conversation with us anyway, because they're not happy with what has happened post-acquisition. So it's got a relatively tarnished image, at least in our world and talking to law firms. Help us or help the audience understand, why is private equity good for law firms when it's not good necessarily for agencies where law firms are the client of the agencies that are acquired by private equity?
I think there's a couple things. I mean, I'm going to speak in particular for the personal injury space. It's currently right now a David versus Goliath battle where you have well-capitalized insurance companies fighting against a fragmented personal injury space, fighting for like the little guy, and it is in desperate need for that capital to compete. But second, in this space, it's a contingency fee-based structure where in this specific business, revenue and profits are only generated when clients make money. Ideally, everyone's a good actor and everyone's doing the right thing. But even the people that are prioritizing profits, and if their motives aren't genuine, it should have the second order effect of greater client experience and settlement values, because that helps the entire life cycle of the industry.
I would say also, fundamentally, those are two different propositions. In one, when you're buying a marketing firm, you're buying the business. That's the business they were in before. That's the business they're going to be in after, and you're in their business. Whereas with a law firm, it's actually not that at all, because the law firm basically has two components. There's the lawyering, and then there's all the admin, right? The lawyers are oftentimes really, really good at the lawyering, and the admin side maybe could be better, right?
Also, the lawyers are regulated.
And the lawyers are, so here you're splitting those two things apart, and where the private equity comes in and helps you do better is in the admin part that the lawyers would never claim they were the best at anyway, and so welcome, the help and they cannot have interference into the lawyering piece, and that's where the lawyers are happy because they get to do what they're good at and they continue to do that. So I think the MSO is not in that business after the deal like they are in the business of the marketing firm that was their business before.
And bear in mind as well that lawyers cannot be bound by non-competes. This is important because if the private equity fund comes in, makes a bunch of changes, and ruins the day-to-day lives of the lawyers, they're simply going to leave. And there's no way for the PE fund to stop them from doing that. And so there's already, as Benji indicated, a unity of alignment between lawyer and client, try to get the case settled.
Yeah, maximize compensation for the client means maximum
exactly
revenue for the firm.
Minimum time to settlement, and then maximize settlement value, right? Very, very simple. And that's exactly what the lawyer wants, and that's exactly what the PE fund wants to enable. And then finally, it's, PE funds have a reputation for short-termist thinking, which I think is actually off, because while they do have, these kind of fixed fund life cycles, 5-7 years, whatever it is in general, they are building the business with a view towards selling it to the next buyer. And that next buyer is going to be conducting all of its own commercial diligence, legal due diligence on the target. If they have built a business that is not set up to be sustainable and durable in the long term, they have failed and their investment is going to fail. So there actually is, in addition to kind of the short term or the fundamental alignment between, client, lawyer, and capital provider, there's also a longer term alignment in terms of trying to build a sustainable business that really will kind of endure into perpetuity.
Yeah, I think this is like one of the only industries where it's direct alignment with the client and the business making money with the contingency fee.
So flip it, right? Play devil's advocate. What is bad? What is the negative about the money coming into the space for law firms?
Certainly, when we think about the sheer volume of capital that is flowing into the market, I mean, a lot of these smaller, more regional firms are going to have a very hard time competing from a marketing and advertising and a case acquisition cost standpoint. And I think they were already under pressure from larger kind of, incumbents in the space that are coming and kind of, deploying the Death Star into, regional market X and,
buying up every single billboard.
Absolutely. So they were already under that pressure. This is going to be an accelerant, I think.
Yeah.
Yeah, I think it's called consolidation for a reason, right? You're going to have, these firms come in and make those plays, continue to acquire, make add-ons so that the market has less players. And, you've seen that even in the UK space, which has had non-attorney ABS ownership. It hasn't saturated, meaning that it's 100% private capital owned. But I think it's probably separated out those that, aren't private equity backed with those that are in certain segments. And so as Josh said, I think it is a competitiveness aspect, but one they're already struggling to deal with, a lot of the founders, how to keep up with the tough marketing with the behemoths of, that play, the Morgan & Morgans, the others that are out there, and continue to grow and invest in technology. But I do think it's going to change the world in a lot of these practice areas, and it may just take some time to get there. But it also really calls some of these founders and operators to the table that you can't do things the way that you used to do things, right? There is new players to the game. There is new competitive pressures. And so you need to invest in technology. You need to invest in better client, customer service communications, right? It's those different things that like the MSO back office has the ability to do. But I do think it will change that the, solo small practice that used to be able to just get by personal brand and reputation and build something bigger. That's going to be a harder uphill battle in certain practice areas for sure.
That is true. We see that as the marketing side, the past 3 to 5 years, especially the past 2 years, there's been a lot of pressure on like, we've seen it. We do with a lot of like mid to large size regional players where they were the big dog in their space. And now all the big dogs from all over the country are coming into the space at the same time. And they're having to compete at a whole nother scale just to keep their market share, let alone grow it. You have a Morgan & Morgan come in, you have a Sweet James come in, you have someone,
Top Dog come in.
Top Dog come in, you have all these big players that you're, instead of competing with one, it used to be just Morgan & Morgan. Now you have multiple while you're still trying to run your firm, grow your firm, be profitable. Just so many new headaches to deal with.
Yeah, you're competing for talent, both on the attorney and on the operations side. Mainly you're competing for cases, right? There's a finite amount of cases. And when you have all of this influx of capital that is more about growth than it is about case cost efficiency, at least in the near term, right? There are definitely second order effects of acquiring more cases because you have your retention marketing to the clients, which helps bring in more cases in the future, whether it's from their referrals or from repeat cases. They're just trying to acquire data, market share. Tactically, what we've seen is it's something very, very, very interesting. Google ads, search ads used to be the dominant way for firms to acquire cases, right? You rewind back, like before local service ads, even at the beginning of local service ads, traditional Google paid search ads were where everyone was putting their money, right? Facebook has grown significantly like over the past 5, 6, 7 years, but historically it was Google ads. Why? Because someone puts in direct, clear intent, car accident lawyer, best car accident lawyer, who do I hire in New York City, etc. And then people can bid for that. What has happened is as we'll call it organic ways of generating cases, right? SEO, map packs, the things that people didn't have to pay for, other than like just doing the right things and like it's a flat cost and the cases will just kind of come in. That has gotten extremely difficult, whether it's the advent of AI eating Google's lunch and people just going to like other surfaces for their initial search, or updates that have happened that have pushed traditional search results down the page. We all know when you Google, you get an AI answer at the top, or then it has ads, then it has map packs, like everything is just getting pushed down. What has happened from like a pure tactical perspective is all the firms that were relying on getting their cases through those organic means have had to go to Google ads to get their cases. The intent is still there. It's just instead of someone clicking on a regular organic result, now you have to buy it. And what has happened is that there's still only 2 or 3 spots at the top of the page, right? Supply hasn't increased, but the demand has gone up exponentially. So your cost per click has gone up, your cost per case has gone up. And for the most part, we don't see any clients in PI running traditional Google ads, and they've shifted their budgets to other places. Just from a pure tactical perspective, having someone come into a market and just say, I'm just going to buy everything, and here's an easy way for me to do it. Every time someone searches best car accident lawyer, I don't care that it's $300 a click. I don't care. I have the money to spend. I'm going to push the small guy out, and I'm just going to buy those clicks up. And the small guys are left holding the bag.
And I think, just as an example or a story talking about that, the negative impacts of this, right? Of having private capital or bigger players move in. I've had a good trial attorneys that have built practices around being a good trial attorney, being very known in, AAJ, other networks of like, they're the go-to, the best litigators out there. But they're sitting there with their firm that's done pretty well. But when they see the big cases, right, the ones that they should be trying, they're obtained by the firms who have spent the big dollars, who may, in their opinion at least, not have the best trial attorneys on their team to do so. And so I think in the future, that's going to be the difficult aspect. What you were saying of kind of just the spending wars to compete and where everybody is going, that good trial attorney probably in the future is going to have to be within that large law firm to try those great cases for the best outcome. They won't be an owner-operator, right? I mean, they won't be able to compete in that space to build a firm on the, historical or traditional model that they had.
Now, we got to wrap this up soon. I would like to get like a prediction from each of you guys where you think the space is going in the next 12, 24 months, what people should be looking out for. It's changing so fast already. Would love to get each of your opinions on where you see it going and the changes that are happening.
I'm happy to go first. I think you're going to see more types of law firms do MSOs. I think personal injury, as we've said, has been the most common. I think you're going to see hourly firms. You're going to see AmLaw, big AmLaw 100 firms. I think the use of the MSO model will expand. I think, and the regulatory landscape will develop with it, but I think those are going to have to develop at this concurrently, basically, just because it's moving so quickly.
Yeah, I think I echoed the same thing. Personal injury is just the starting point. You'll definitely see more practice areas get involved, including probably mass tort at some point, particularly that bucket of personal injury firms that dabble in mass tort will definitely start to get a look. I think you will start to see the acceleration of the bigger players taking out the smaller players. But in addition to that, it's also going to accelerate the AI adoption, and that's going to have a massive impact throughout, particularly the personal injury space.
Yeah, I'll focus on that technology theme for my comment. You are going to see incredible disruption in the practice of law driven by AI. That's going to happen at every single segment. PI, mass torts, absolutely, but also for the larger corporate and AM law firms. One of our clients, Norm AI, we help them with establishing Norm Law via an MSO structure. They took in $50 million of equity financing from Blackstone, and they are hiring partners from Sidley and Ropes & Gray and the biggest AM law firms out there in order to construct like an AI native or AI first thesis, right? And their goal is to grow to be an AmLaw 50 firm within the next few years. So we're going to see incredible disruption.
Absolutely. I'd agree with all of those comments, plus the aspect of everybody asked really from a transactional side, like how many of these deals would we see over the next, year or two or otherwise? I think you're talking hundreds, right? Easily. And that's private capital and law firm deals and otherwise that are going to happen, this year and next year. And then you're talking about moving into the thousands. And that's really just an aspect of, the firms that are taking the steps now to do MSOs, the private capital that's investing, the firm mergers that are happening to really roll into consolidation and there is a succession need. There is still a lot of law firm founders that have no plan and still own the firm either themselves or, with one other partner of the same age, and they're going to need an exit strategy. And so that's where a lot of the new options that are available and everything else, you're going to see those deployed on a, faster and faster kind of scale over the next few years.
Awesome. Very much appreciate you guys taking the time joining us in the podcast.
Thank you for having us.
Yeah, I think this was a great episode for firm owners who truly want to understand the current state of the market and what is being looked at from the sell side and from those in the middle, helping negotiate these deals. So really appreciate it. Thank you guys so much.
And real quick, if people want to get in touch with any of you with follow-up questions, how can they reach you? Real quick.
They can email me at bziser@mcdermottlaw.com.
You can reach me at Benji, BENJI, at cisplatform.com.
This is Josh Porte. You can find me on LinkedIn or you can email me at josh.porte@hklaw.com.
Yep, Tom Lenfestey. You can also find me, of course, on LinkedIn otherwise, or visit us at thelawpracticeexchange.com.
Thank you so much, gentlemen.
Thank you.